In this lecture, we would like to discuss about maintenance to divorced women under Islamic law, so also relating to triple talaq. That's why we have entitled the very lecture as from Shah Bano to Shayara Bano, and in particularly we would like to tell the very provisions of Muslim Women Protection of Rights and Divorce Act 1986 and also Muslim Women Protection of Rights and Marriage Act 2019 and the very application of the provision of Section 125 of the Criminal Procedure Code relating to right to maintenance. So, in that particularly, we would like to discuss about the very judgment delivered by the Supreme Court, where it has ruled that divorced Muslim women can claim maintenance from husband since the Shah Bano judgment of 1985. Several rulings of the Supreme Court, including its triple talaq verdict in 2017 in the important leading case, that is Shayara Bano case of 2017, show how it has empowered Muslim women in India. So, the Supreme Court of India on Wednesday held that a Muslim woman divorcee is entitled to maintenance from her husband even after divorce under Section 125 of the Criminal Procedure Code. It's not a charity but a right, the court said while delivering the verdict. This is among the several rulings of the apex court that has gone to empower Muslim women in India. So, we would like to discuss all these important leading cases, in particularly the very important leading case where the bench of Justice B.V. Nagrathan and Augustine Judge Massey held that the law for seeking maintenance should be valid for all Muslim women and not just married women. The Supreme Court also held that Muslim women's Protection of Rights and Divorce Act 1986 passed by the then government in response to its Shah Bano judgment of 1985 will not prevail over secular laws. The ruling thus would have a significant impact on the rights of Muslim women in India, as it marks a crucial milestone in their quest for equal rights and empowerment. Cloud with the recent judgment in Shayara Bano case in 2017, the journey so far long and arduous has been shaped by the several key Supreme Court judgments and those landmark judgments that have played an important role in shaping the legality with regard to the rights of Muslim women in India. In particularly, we would like to discuss the most important judgment related to Shah Bano Begum versus Muhammad Ahmad Khan in 1985, where regarding maintenance that relates to, in particularly this judgment as it relates to the crucial moments of the history of Muslim women's right in India, as in particularly in Shah Bano, where divorced woman had filed a suit for maintenance against her husband Muhammad Ahmad Khan. The Supreme Court ruled in her favor, granting her the right to maintenance under Section 125 of the Criminal Procedure Code. This judgment sparked widespread spread controversy with some Muslim bodies, politicians, and clerics arguing that it was in conflict with the personal law of Muslims. In response to the backlash, the government, the then Parliament and government enacted the Muslim Women Protection of Rights and Divorce Act 1986. The act restricted the right of Muslim divorcees to alimony from their former husbands for only 90 days after the divorce, and that 90 days period is known as Iddat Period. The act was seen as discriminatory as it denied Muslim women the right to basic maintenance available to women under secular law. The law would be challenged and the Supreme Court would give verdicts against the 1986 Act, though among the most well known of its judgment, there were earlier instances too when the verdicts of the Supreme Court empowered women. So, in that connection, we would like to discuss the most important leading case, that is Daniel Latif versus Union of India, and in particular in the year 1986, the constitutional validity of the Muslim Women Protection of Rights and Divorce Act 1986, but why the then government was challenged before the Supreme Court in the Daniel Latif versus Union of India case. Daniel Latif was the advocate who represented Shah Bano in the Supreme Court. The court interpreted the act in a manner that upheld the Shah Bano's husband, effectively nullifying the restrictions imposed by the 1986 Act. This ruling marked a significant shift towards recognizing the rights of Muslim women to maintain them beyond the Iddat period. This case ensured Muslim women receive fair and reasonable assistance to live their lives with dignity. And another important leading case is the Noor Shah Khatun case of 1997, where in this case Supreme Court held that a Muslim woman could claim a share in ancestral property under the Muslim Personal Law or Sharia Application Act of 1937. And also, the decision acknowledged the property rights of Muslim women and empowered them economically. And another important leading case relating to maintenance is Malana Abdul Qadir Mudani case of 2009, where Supreme Court affirmed that the right to practice religion does not include the right to violate fundamental rights of others, particularly in the context of gender equality. This decision reinforced the principle that personal laws must be in conformity with constitutional rights, thereby empowering Muslim women by protecting their rights against discriminatory practices. And another important leading case relating to right to maintenance of divorced Muslim women is Shah Bano versus Ashraf Khan, decided in 2014 in relating to particularly maintenance, where the Supreme Court delivered another important judgment, and it held that a Muslim woman was entitled to maintenance from her husband even after divorce and could file an application before a magistrate's court. The judgment emphasized that a Muslim husband was liable to make a reasonable and fair provision for the future of the divorced wife, including her maintenance, which extended beyond the Iddat period. And the most important judgment delivered in 2017 relating to Shayara Bano case and in particularly relating to triple talaq show the very landmark case that Supreme Court were declaring the very practice of triple talaq, instant divorce, which is under Islam is otherwise called as Talaq-e-Biddat, and it was applied in particularly in Shayara Bano case, and where the court ruled that declaration or declaring the very practice of triple talaq or instant divorce as unconstitutional and invalid. The court ruled that triple talaq violated the fundamental rights of Muslim women, providing them with protection from arbitrary divorce and empowering them with legal courses. The cumulative effect of these Supreme Court judgments over the years has been meant to empower Muslim women in India by recognizing their rights to maintenance and challenging the very patriarchal norms that have historically restricted their rights and growth. These rulings have not only upheld the principles of gender equality and justice, but have also paved the way for further reforms in the lives of Muslim women. They have played a crucial role in empowering Muslim women in India. So now we would like to discuss how does triple talaq violates the fundamental rights. So in that case, we would like to discuss the various provisions relating to triple talaq and how it violates the very fundamental rights of the Muslim woman. And in that context, we would like to discuss the constitutional provisions relating to that debate, which is that the legal prohibition on triple talaq was established in India as the enactment of Muslim women's Protection of Rights on Marriage Act 2019 marked the culmination of extensive debates and struggles. This act rendered triple talaq illegal in India starting from August 4, 2019. It explicitly declared that any form of instant triple talaq, whether spoken, written, or communicated electronically via means such as email or SMS, was void and unlawful. Moreover, the Act mandated penalties including imprisonment for up to 3 years. Her husbands found guilty of employing instant triple talaq, as it completely violates fundamental rights as enshrined under the Constitution of India, and in particularly it violates right to equality as provided under Article 14 of the Constitution. So the very practice of triple talaq discriminates against women by allowing husbands the unilateral power to divorce their wives while denying the same right to women. This unequal treatment based on gender goes against the principle of equality as under Article 14 of the Fundamental Rights of the Indian Constitution, which guarantees equal protection of the law to all citizens, and further, it also violates Article 15, which relates to right to non-discrimination. So, in particularly, Article 15 prohibits discrimination on ground of religion, race, caste, sex, or place of birth. So triple talaq, which primarily affects women, constitutes discrimination based on gender, violating this provision. Further, right to protect the dignity of women as provided under Article 15, Clause 3. It also empowers state to make special provisions for the protection of women and children by declaring triple talaq unconstitutional. The Supreme Court upheld the dignity and rights of Muslim women, and further triple talaq violates right to freedom of speech and expression as provided under Article 19. So, the very power to divorce a spouse through triple talaq is exercised through verbal communication. However, this right to expression should be balanced with other fundamental rights. When triple talaq is used to divorce a woman without her consent, it can infringe on her fundamental rights, and further, it also violates right to life and personal liberty as provided under Article 21 of the Constitution. So triple talaq can have severe emotional, psychological, and financial implications on women who are suddenly divorced without their consent. This violates their right to live with dignity and personal liberty as guaranteed under Article 21 of the Fundamental Rights. And further, it violates right to freedom of religion as provided under Article 25 of the Fundamental Rights as enshrined under Part 3 of the Constitution of India. While individuals have the right to follow their religion and its practices, the practice of triple talaq was found to not be an essential part of Islamic religious practice by the Supreme Court. Therefore, banning it does not infringe upon the right to religious freedom as guaranteed under Article 25 of the Constitution. So, in particularly in this very important leading case relating to Shayara Bano case of 2017, the very judgment delivered by the Supreme Court, it made a landmark change of the impact of over the personal law of the Muslims. So, the very judgment of Supreme Court of India in declaring the very practice of triple talaq as unconstitutional. In a historic ruling, it was a panel of 5 judges from the Supreme Court concluded that the practice of triple talaq, which allowed Muslim women to divorce his a Muslim man to divorce his wife by uttering the word talaq 3 times repeatedly, was in violation of the fundamental rights of Muslim women, and so these are unconstitutional. Among the 5 judges, 3 were in agreement that the practice was unconstitutional, while the remaining 2 upheld its constitutionality. In its judgment, Supreme Court noted that triple talaq allows a husband to end a marriage at his whim without giving the wife any say in the matter. This unilateral and arbitrary nature of the practice undermines the principles of equality, dignity, individual rights, which are the cornerstones of Indian Constitution. As a result, the court concluded that triple talaq is incompatible with these fundamental rights and therefore unconstitutional. The court's decision was grounded in the belief that this practice undermined principles of gender equality and dignity. The court emphasized that triple talaq was not an inherent aspect of Islamic religious tradition and thus could be set aside due to its infringement on rights of Muslim women. So the ruling was held as a significant stride towards the empowerment of Muslim women and the safeguarding of their rights as enshrined in the Indian Constitution. So, consequently, the legal prohibition on triple talaq was established in India. So, the enactment of the Muslim Women Protection of Rights on Marriage Act 2019, which marked the culmination of extensive debates and struggles, and it was finally came into effect on August 1st, 2019 by declaring any form of instant triple talaq or Talaq-e-Biddat, and its very performance and continuance as unconstitutional and illegal. So we have concluded our lecture on the very important aspects of maintenance to Muslim women after divorce and also relating to how triple talaq becomes illegal and unconstitutional as declared by the Apex Court in this important leading case of 2017, that is Shayara Bano case. And finally, the Parliament of India enacted Muslim Women's Protection of Rights on Marriage Act 2019.